Welcome to our session. Today, the session title is entitled Deconstructing the Bail Myth, the False Promise of Money Bail. And we have two presenters from the Vera Institute of Justice here to present. So I'm going to pass this over to them and they'll present. And at the end, we'll take questions. Thank you very much for attending.
Thank you, and thank you for coming. So yes, we're from the Vera Institute of Justice, and just for those of you who don't know who we are a 60-year-old national research and policy organization, and we focus on criminal legal system reform. My name is Aiden, and I guess I'd just like to share briefly kind of what brought me to this work. I've been with Vera for about 1.5 years now, working on national pretrial reform with Madeline. But I came to this issue because my background was as a public defender. I spent almost a decade as a public defender. And so this is an issue that I would say is near and dear to my heart. I represented over my time thousands of clients and really got to see firsthand the destruction that our current bail system wreaks on people's lives. I had countless clients, lose housing, lose their jobs, be stressed about, they have a pet at home. What are they going to do? They know they're going to be held in on jail. And I can't tell you how many conversations I had with people where they felt the need to plead guilty to something just so that they could get out of jail, regardless of whether or not they were guilty with what they were charged with. So that's a little bit about me and what brings me to this work. And I will pass it to Madeline to introduce herself.
Yeah, hi everyone. Thanks for having us today. Similarly to Aiden, my background is as a lawyer. After law school, I initially joined an organization doing capital defense and appeals specifically for people who were sentenced to death. I would say through that work, it was definitely difficult work, and it gave me a real appreciation for just the compounding harm that happens over the course of somebody's case and how critical those early decisions are to setting someone up to actually fight their case. And so that's kind of how I became focused on pretrial and bail, just because, just as Aiden said, they can really make or break somebody's case and have so much effect on where things go from the beginning. So I just wanted to start off by giving you a little bit of a roadmap for where we hope to go today. Our presentation today is really focused on, again, breaking down that myth that cash bail is an effective and necessary part of pretrial systems. I'm sure you all have seen in the news right now, politicians are very eager to equate bail policy with crime and safety, and really are consistently and erroneously blaming the nationwide crime trends on bail reform and pretrial policy. And so we wanted to kind of take a step back and really reflect on the history of bail, how the system came to rely so heavily on cash bail, give you some arguments in favor of actual pretrial reform and doing things differently, correct some very rampant and common misconceptions around bail, and then offer some examples for actually achieving pretrial reform and different ways of getting at change. So again, let's start by sort of taking a step back and understanding how our system of cash bail really came to be. So in early American history, the term bail simply meant release. And as I'm sure all of you know, bail bonds and commercial sureties really have co-opted that term to sort of equate with actual money. But bail bonds originally were intended only to ensure someone's appearance in court and to protect against someone from absconding, from fleeing, from not actually showing up to trial, and essentially just required someone to pay money only if they did not cooperate and show up for trial. So originally, all charges, with the exception of just the very most serious charges, were considered bailable, which is why in many state constitutions, you'll see that exact language. Only the most serious capital murder are actually where judges are actually authorized to hold somebody without setting any sort of bail. So again, over time, the concept of bail has really been influenced by bail bondsmen, commercial sureties, such that now when we hear the term bail, most people will just assume that means cash bail. And we also wanted to sort of highlight one of the seminal Supreme Court cases on bail. Stepping back from what the decision actually did, there's some really helpful language in there that we kind of try and ground all of our work in. And that's that in our society, pretrial liberty is the norm, and that detention prior to trial or without trial is the carefully limited exception. However, we know that the reality is this doesn't play out that way in most states and localities, unfortunately. So before I kind of talk a little more about influence of the bail bond industry, I want to just give a quick grounding and explanation, talk through how the system works in really broad terms. So after someone is arrested and booked into jail, they will usually see a judge for a decision on their bail in a relatively short period of time, in many places about 48 hours. And at that hearing, the judge will typically make a decision on that person's bond amount. Now, if that person can't afford to pay the full amount, they can pay that amount to the judge, and they will get or the court, and they will get all of that money back if they attend court as required. It's sort of that down payment they'll get back if they hold up their end of the deal. But if, in many cases, in the vast amount of cases, the person accused will not be able to actually afford that full amount, and the system has sort of become such that that's almost a certainty since bond amounts are so high. And in that case, the person can go to a private bondsman for help paying. And bondsman will require that person to provide a payment of a certain percentage of the total bond amount. So usually like 10% for the bondsman to cover the rest with the court. And the critical detail there is that even if the person shows up for court as required, they will never get that 10% back. That's something the bail bondsman is going to pocket and keep regardless of the result of the case. So you can kind of see, based on how the system works, that the for-profit bond industry has an enormous economic incentive to promote the practice of judges setting money bail and to continue to set those amounts higher than people can actually afford, so that they must rely on the bail bond industry. Each year, the bail bond industry underwrites about 15 billion in bonds, with an annual profit of 2.4 billion. And this, as we have discussed, creates a very flawed incentive structure. Due to the bail bond industry's financial interest in continuing the system, they often spend just an enormous amount of money lobbying and fighting any reforms that are sort of coming up in state legislatures that propose to do things differently. So from 2010 to 2020, the bail bond industry spent over 23 million in lobbying and campaign contributions for politicians, just to sort of stop any change from actually happening. And this was a 10-fold increase from the amount they spent in the previous decade. So we can really kind of track it as a response to more reforms coming about. They're going to spend more money to stop the system from changing. So the result of all of this is that pretrial policies have caused a surge in the portion of the national jail population who is incarcerated in jail waiting for trial. So that's about actually 62% of all jail populations are actually made up now of people who are in the pretrial stage of their case. And you can also get a sense from this graph how much pretrial detention in our country has increased in the last several decades. So since 1970, which is beyond this chart, sadly, pretrial detention has increased by about 433%. And you can see that the convicted population has sort of leveled out, while the proportion while the amount of people in jail for pretrial detention is continuing to go up even after that convicted population is leveling out. And just to give you one last kind of statistic, Nationwide, the average felony bail amount is set at about $10,000. That's really not an amount that most people can afford to pay. And in some places, those amounts are much, much higher. California, for instance, is one of the states where bail amounts are actually astronomically high. So for serious and violent felonies in California, the median bail amount is actually 1.4 million. For non-serious and non-violent felonies, the median bail amount is 365,000. And for misdemeanors in California, the median bail amount is $55,000. So you can really see just how that's just really not going to be possible for someone to pay without relying on a bondsman.
So again, excuse me, part of what we wanted to do here today is respond to, many of the misconceptions that are out there around bail. And one of the big ones is that bail reform is not connected to rising crime. As I'm sure all of you know and have seen, there has been a recent rise nationwide in violent crime. But the way that that issue has been spun, especially by the media, by politicians, would really cause people to cause doubt on whether bail reform is actually good for society and good for public safety. Our current political climate has really enabled politicians to latch onto bail reform as kind of an easy place to focus the blame for any rise in violence and any instability they're seeing in their community, even when those issues are not connected. And I think it's fair to say that it's become clear to many politicians on both sides of the aisle that they've made this calculus that a return to the kind of tough on crime rhetoric and the law and order, that's politically advantageous to them. However, there's no data to back the false claims that bail reform is causing a rise in violence. We've seen violent crime rise in many places in the US, starting in 2020 and then continuing to 2021. We've seen it in cities and in rural areas. We've seen it in red states and we've seen it in blue states. And since 2020, homicide has increased in 45 out of the 50 states. But this includes states that have passed pretrial reform and, just importantly, states that have not passed any reform. And something that's kind of interesting, if you do more of a deep dive and you take a closer look at the national homicide rates, what it actually reveals is that states with the lowest rates of pretrial incarceration also have the lowest homicide rates. So another myth that we wanted to tackle is really that money bail does not promote public safety. And one thing that I think can be a little bit counterintuitive to people is the fact that pretrial detention has actually been found to lead to an increase in rearrests, not a decrease. And if we just kind of step back and think about that for a minute, it logically makes sense. If we think about how destabilizing incarceration is, even a short period in time can cause, like I was saying before, I've seen firsthand, can cause a person to lose their job, lose their housing, and think of all the disruptions that can cause in their family. And that can really destabilize a person's life. And there's really been long studies that support this. There was a very long-term study out of Kentucky with a really big sample size. They followed 1.5 million cases. And they found that when people are detained for just 24 hours or longer, the likelihood of rearrest actually increases. And again, that goes back to that destabilization. Something else that's interesting is that pretrial detention, it's actually been linked to an increased likelihood of rearrest far in the future, not just immediately following release. That same study that I mentioned from Kentucky, it actually followed people for a longer period of time. And it found that those people who were detained for just 2 to 3 days, even 2 years later, they were 17% more likely to be rearrested. And for those who were detained for longer periods of time, 15 to 30 days, that percentage increase of likelihood of rearrest jumped to 46%. And again, I think if we step back, it kind of intuitively makes sense. When somebody's life, is destroyed and their economic, resources are whittled down, it takes time to recover from that. And that destabilization can last for a long time. The other thing I would note is that, there have been places that have done reforms and they've maintained a very high public safety rate. One state that I could highlight for you is New Jersey. So they implemented their reforms in 2017. And since their reforms, they have maintained incredibly high public safety rates. And they've released the vast majority of people who are charged with an offense. They actually only detain about 6% of everybody who's charged with an offense. That is significantly lower than most of the rest of the country. After implementing these reforms, they found that their jail population dropped by about half. And in the years after implementing the reforms, they found that violent crime decreased by about 16%. So something that's just important to note is that effective pretrial reforms actually protect public safety. They eliminate some of those harms that I was speaking about in terms of cycle of rearrest, criminalization, poverty, but they don't actually increase rates of rearrest. One example to highlight for you would be Harris County, Texas. They had county level reform subject to a standing order within the court as a result of some litigation, and they implemented their reforms in 2019. And just to explain a little bit about what their reform looks like, essentially the vast majority of people who are charged with misdemeanors have to be released without having to pay money first. And the effect has really been enormous. Prior to that reform, 92% of people charged with misdemeanors had secured money bail set. And that number has been reduced to 14%. But despite this steep reduction in the use of money bail, public safety was not compromised. As a result of that settlement there's actually a federal monitor that watches, gathers data, and every 6 months they publish a report. And report after report has shown that the number of people who are released pre-trial and then get rearrested has actually maintained steady and actually has decreased slightly.
So another myth about money bail is around court appearance. And money bail is not actually necessary to ensure return to court. And that's been really verified by a lot of research. So one study that we wanted to highlight from the City of New York's Criminal Justice Agency found very little impact in terms of money bail's connection to court appearance rates. And these numbers are so stunning that we wanted to just put them up here so you can get a sense. 88% of people released without bail or conditions at all made all of their court appearances. 91% of those released on financial bail made all of their court appearances, so very little difference. And 92% of those released without financial bail and with supervised release, so with some supports, with some accountability other than money bail, made all of their court appearances. So you can really tell that, financial bail is not what's making people return to court. And pretrial detention, as Aidan has talked about, may actually increase the likelihood that the person will not be able to appear in court as they are required during a case. So that study from Kentucky controlled for factors such as people's assessed risk level, their charge type, demographics, and revealed that people who were held in jail pre-trial for even 2 to 3 days were much more likely to fail to appear on their case than those who had been released promptly within 24 hours. And this is really because of that destabilization that occurs when somebody is incarcerated for a few days. Only a couple of days in jail, as we've emphasized, can be plenty of time for somebody to lose their job, to lose their housing, and to create a lot of instability within someone's family. So next, research has shown that people who are detained pre-trial are actually 25% more likely to be convicted of their charge than other people who are similarly situated who are released prior to trial. Most of these convictions for people detained are brought about pursuant to plea bargains, which is not uncommon, as many of you, I'm sure, are well aware. It's very common for someone to receive an offer of a sentence of time served, meaning they've already served the sentence in jail that they would be sort of pleading guilty and receiving. So it's giving people this really unfair choice of, pleading guilty and getting to go home that very day, as opposed to continuing to wait for their day in court on the off chance that they, are able to resolve their case or able to get that acquittal. But during that time, they're just waiting for longer than their sentence would actually be if they were to just plead guilty. So, and also, I think just bringing it back to what we've talked about a lot, and that point we keep returning to, is people know that if they remain detained, they're going to lose their employment, they may lose custody of children or other sort of really critical things like that. And it's just kind of shocking that people are put in that position just day after day. And research also makes clear that controlling for other factors, people detained pretrial are 4 times as likely to be sentenced, kind of because of the prevalence of that sort of false choice they're given. And on average, that sentence that they receive is likely to be twice as long as a person who has been released from jail pretrial.
Yeah, so Madeline talked about the different consequences that happen to somebody's actual case because of the fact that they're detained pre-trial. But just kind of as I was alluding to early on, being detained pre-trial has consequences to a person's life that extend outside of the legal system. And again, I saw that personally all the time, so I know it to be true, but we wanted to share a little bit of the research with you. So of course, employment consequences. The research tells us that even a few days spent in custody leads to a much greater chance of losing employment. And of course, this doesn't just have consequences for that person who's being accused, but it has consequences for their families, for their children, for their communities. And interestingly, these consequences, they're not just immediate, they can last for years. There have been studies that have shown that pretrial detention decreases the likelihood of employment even 3 to 4 years later by about 10%. Again, families are impacted financially. When the primary financial support for the family is incarcerated, studies have shown that that family income declines by about 22%, and about 65% of those families are no longer able to meet their basic needs. And so then they're more likely to need to turn to public assistance to survive, and children are more likely to experience homelessness. Of course, housing consequences are big. When people are detained, how are they going to pay their rent? And all of a sudden they've lost their housing. And research has shown that people who were formerly in custody are about 10 times more likely to experience homelessness than the general public. Custody is a real concern. When people are detained pre-trial, the likelihood that their children are going to be placed into foster care increases. And it's very common for parents to actually lose custody of their children, regardless of how minor that offense is that they're being jailed for. As I'm sure you all know, the health consequences of being detained in jail are just enormous. There's overcrowding, the medical staff, they're understaffed. There's limited treatment options. There's rapid spread of disease. And I think we all really saw that, and that was really magnified during COVID. That was an incredibly dangerous place for people to be. Jail also greatly increases a person's risk of overdose and suicide, and it puts them at a much greater risk to be the victims of violence. Another issue that is, in a lot of ways, from my experience, I saw it related to health, is that many states have a policy in place where if you enter jail, your Medicaid benefits are essentially cut off. And they, once you get out, you have to essentially reapply and go through the months-long process to get those benefits again. And what I often saw in my practice was the health implications of that, because we know that a lot of people who are incarcerated have, substance abuse struggles or mental health disorders, and then they're not able to access the medication they need to stabilize, which again creates this cycle that we see. And so we talked a little bit about the impacts of pretrial detention. And I think it's really important to highlight that communities don't share that burden evenly. Certain communities are disproportionately harmed. people of color are disproportionately harmed by the money bail system. What research has shown is Black and Latinx people comprise about 30% of the US population, but make up over 50% of all people who are detained pre-trial. Simply being Black increases a person's likelihood of being detained by about 25%. And in addition, controlling for other factors, studies have shown that comparing Black men to white men on the issue of bail, Black men are more likely to have money bail set, and on average, those numbers are about 35% higher. People experiencing poverty. What we know is that people who are in jail are drastically poorer than the general community. The median annual income for people who are held pre-trial, it's about $15,000, and that's about half of what the population that is not in custody. There was a study in Philadelphia that found that 40% of people who had bail set at 500 or less, which in our bail system actually is a pretty low number, were not even able to afford to post that. LGBTQ people are disproportionately impacted. Studies have found that about 75% of people who identify as LGBT who are detained pre-trial are there because they cannot afford the bail in their case. And what we also know is that LGBT people are at higher risk of violence when they are incarcerated. Another impacted community is people that have behavioral health challenges. Studies have shown that about 1 in 5 people who are held in jail pre-trial have a serious mental illness, and about 68% have a substance use disorder. But only 11% of people with a substance use disorder actually receive the treatment they need while detained. Women are disproportionately impacted. On average, women who are detained pre-trial, they have a median annual income of about $11,000, which really, when you compare that to the fact that we know that the average bail set is $10,000, that is striking. And in addition, research has shown that women are more likely to plead guilty just to get out of jail because they feel that they need to go take care of their children.
So now that we've discussed a lot of the harms, shared with you a lot of the research around why our current pretrial system is harmful and ineffective, we wanted to pivot and talk about policy and practice changes to actually achieve pretrial justice, or something that looks a lot closer to pretrial justice. And we wanted to highlight a couple different mechanisms that we see in our work across the country in terms of how different states and localities are actually getting at that change. So the first mechanism for change that many people probably think of is changing statewide bail policies through legislative change by introducing bills that propose to drastically change state level laws. These laws are often often current state laws don't go into a lot of detail around how judges should make bail decisions and leave a lot of discretion to local courts for figuring out how to do that. States that have achieved pretrial reform through the legislature have actually given a lot more bright line rules that place limitations on judicial discretion, especially when it comes to low level charges. So just sharing a few of the boldest state level legislative pretrial reforms to date. You've likely heard about Illinois in the news. They are actually the first state to completely eliminate the use of money bail. That will go into effect in January of 2023. And unfortunately, there's been a lot of backlash before it's even gone into effect. So I would encourage you all to keep your eye on Illinois and hope that they can weather sort of the political moment to actually see what a system would actually look like without money bail. They've got a really strong law in place that would focus the judicial decision on risk and safety, as opposed to setting amounts and people getting released depending on whether or not they're able to actually pay. We also wanted to highlight New York. New York's bail reforms went into effect in 2020 and created a large number of offenses for which money bail just simply cannot be required as a condition of release. And despite what the media likes to emphasize, these reforms have actually been very successful. 84% of people arrested are eligible to be released without paying money bail. The jail population across the state has decreased by about 30%. And importantly, the stat that most media outlets don't report is that the rearrest rate for people who are released pre-trial actually decreased. It did not change very much at all. It was a very slight decrease. And less than 3% of people are rearrested for a violent felony when they're out on pretrial release in New York. We also mentioned New Jersey. So New Jersey's reforms took effect in 2017. And Aidan mentioned that 93% of people in New Jersey are released without having to pay any sort of money. And that's resulted in a 50% decrease in the statewide jail population. It's also important to note that less than 1% of people there are rearrested for a serious or violent felony. And they have a pretty robust pretrial services system that Aidan will talk about in a few slides. Also just important to note that there are still current state level legislative efforts underway to affirmatively change state laws to better achieve pretrial justice. Those are really the most underway right now in Michigan and Ohio. Other states are perhaps trying to go the opposite direction. And so there's a legislative fight in other places like Texas to kind of prevent things from getting worse. So another mechanism for achieving pretrial justice is through changing court rules. So many states allow for the promulgation of pretrial policy through changes to the unified court rules that all courts across the state have to follow. And a great example of this type of pretrial change is in Kentucky. They did this through the practice of what they call administrative release, which requires automatic pretrial release for most misdemeanors, meaning that people charged with most misdemeanors don't have to go before a magistrate or a judge for a hearing, just simply based on their charge and another review of their case. They get to just be released without any sort of bail set. And this was actually expanded in 2020 to also include low-level felonies because the data was just so positive. And now 90% of people released in Kentucky through this administrative release policy are not rearrested. We also mentioned Harris County, Texas already. As I think Aidan already covered, this reform came about because they were sued. But that's okay. They changed their court rules to comply with the federal litigation and implemented a reform via court rule, Rule 9, that has resulted in the majority of people charged with misdemeanors, again, being automatically released without bail. So prior to reforms, just to give you a sense of the scale of how much this changed things, 92% of people in Harris County, Houston, who were charged with a misdemeanor had secured money bail set on their case. So 92% of people had to pay money for misdemeanors to get released. And that number has now actually been reduced to 14%. So it's had a pretty strong effect. Another way that some places achieve pretrial reform, one that's pretty loud in the media, is reform that's actually led by prosecutors at sort of an office level policy or local policy. So prosecutors can harness their tremendous power within the criminal legal system by implementing policies that will reduce the level of pretrial detention and reduce the use of money in the system. Prosecutors' offices should have policies in place directing that they will not seek bail for certain low-level nonviolent offenses. And while judges are ultimately the ones who make the final decision on bail, we see just everywhere that they're very swayed by the requests made by prosecutors, and the fact that prosecutors are not requesting bail amounts that are based on money will have a lot of influence with judges. Prosecutors' offices can also offer affirmative support to countywide and statewide efforts at reforming pretrial practices. Things like, prosecutors who are willing to go offer public testimony in support of positive changes, leveraging the support of law enforcement and helping to educate on why cash bail is not effective at protecting public safety will have a big impact. And we wanted to share one example of a prosecutor-led reform out of Philadelphia. So there, the DA's office, Larry Krasner's office, stopped requesting cash bail for many people charged with an offense. And that policy led to an immediate 23% increase in the number of people released without having to pay money, and a 22% decrease in the number of people who had to spend at least one night in jail. And importantly, there was no increase in recidivism after these policies were enacted, and failures to appear in court did not increase.
I wanted to talk a little bit about supported pretrial services. So part of what Madeline and I do in our work is we go across the country and we talk with lawmakers, we talk with judges, we talk with prosecutors, and they're kind of like, okay, I get it. I understand what you're saying. Money bail is bad, but what's the solution, right? Because this system has been so entrenched and increased over the last 40 years. Sometimes it's hard for people to think outside the box and think of a different way of doing things. And one solution that we often point to is, to provide supportive services that look to address the root cause of why people are often getting entangled in the system in the first place, and to provide supports so that you can help them during that pretrial period so that they can be successful. What we know is that issues such as lack of transportation, lack of childcare, losing track of the correct court date, that those are the reasons that people miss court. It is unbelievably rare. In fact, I never had it in my 10 years of practicing that somebody is actually fleeing from prosecution. There's all kinds of other reasons why they're missing court. And one very easy solution that has been found is that when you provide people with court date reminders, so think similar to if you have a doctor's appointment or a dentist appointment, you get that text, a day or two beforehand to remind you that you have this appointment. Same type of thing. That's been found to reduce the rates of failure to appear by as much as 43%. So it's incredibly effective, and it doesn't cost a lot of money. And there have been studies that show, if you can kind of pair that court date reminder along with a reminder that there are consequences if you fail to miss court, that is incredibly effective at getting people to their court date. One county in Oregon implemented this exact type of policy, and they found that in just 6 months, they actually saved the county $232,000 because it's costly when people miss court and warrants are issued and they have to be rearrested. And what we found is that pretrial services, it's most effective when it's separate from law enforcement and it's housed within the community. Ideally, the way this would look is, if somebody is released without having to pay money, they immediately meet with a social worker. And that social worker is trained to do a needs-based assessment and understand what this person needs, what supports they need to be successful pre-trial. And then from there, what happens is they have relationships with community organizations, and they'll refer that person to an organization that can meet their needs. And there's many of these programs across the country. We're just going to highlight a few of them for you. The Bail Project, which many of you have probably heard of, found that at one of their sites, about 70% of their clients reported needing transportation support in order to make their court date, and about 75% needed childcare support. And so they offered that to people, and they found that after providing those services, over 90% of their clients made all of their court appearances. Another one to highlight to you is, of course, we know homelessness, is a big issue, and of course that creates barriers to making it to court. So the San Francisco Pretrial Diversion Project they actually began providing supportive housing to unhoused people pre-trial. And they found that 97% of their clients made every court appearance. It's important as well, of course, to address behavioral health challenges through supportive services. In Santa Clara, there was a program that was called Partners in Wellness, and they saw that there was an 83% reduction in the number of days people spent in jail because they were able to take advantage of that support and that behavioral health services. One last one to highlight for you is there was a program called Chicago Cred, and what they did is provide things like employment, education, trauma therapy to people that were living in more violent and high-risk communities. And they found that by providing those services and those supports, that there was a 50% decrease in violence in those communities. So that is all the talking at you that we have for today. We would love to open it up for questions and to have a conversation.
Oh, thank you so much. I really appreciate your presentation. We see so much about bail reform and money bail and things like this. So it's very helpful to learn more about, how it operates, the differences in some states, and then also the devastating impact it has on people in so many different ways, from health outcomes to housing to family issues, employment. So thank you so much for sharing that. We'll open this up for questions. If you have a question, feel free to post it either in the Q&A section, in the chat, wherever you feel is easiest for you, and then we'll have our presenters answer it. Just leave a few moments for that, but I just want to thank you so much for presenting. It's so informative. I learned so much, so thank you so much for that.
Yeah, thank you for inviting us to share.
Thank you.
I appreciate it.
And if we get no questions, we'll assume we covered everything.
Yeah,
Right.
it was very informative, and honestly covered so much. Typically I'm guilty of this myself, but it's easy to present a lot of the issues but not really offer solutions. So to be curious to see how things work out in states like Illinois with the upcoming reforms, and it's encouraging to see somehow some of the reforms have gone so far in other states that have passed them.
Yeah, it's so frustrating that even before anything has been actually implemented in Illinois, there's already so many attacks. And I mean, opponents are just pouring money into sort of riling up opposition already. There's been fake newspapers that were printed that just contain story after story about crime that were delivered to people all across the Chicago area, ads that are really racially charged and just completely false, that are just solely meant to cause fear. And I think it's hard to always be on the defensive in terms of going back to statistics about why pretrial reform actually protects public safety as opposed to the alternative. Just because when you're competing with the fear, it's hard to just get people's attention. So we try and really lead with solutions as much as possible to sort of get away from that problem.
Oh yeah. I feel like across the United States, especially election time, it's very shocking to see the things that are displayed and given out and passed around and things like this. So it's heartbreaking, really. I actually don't see any questions. You really did give a very thorough
that means we nailed it. There's
you really did. Well, I guess I'll just conclude then. But if any panelists want to reach out privately, you're at the Vera Institute of Justice. We want to thank you so much for presenting. Thank you so much for your time. You've been so enlightening. We have many, we're just very grateful to you. So thank you so much for all the work you do. It's so very necessary, and you're improving your society in so many ways. So thank you for all you do. I appreciate it.
Thank you. Appreciate it.
Yeah,
Thanks.
thank you. Take care.